I want to bring in NBC News correspondent Blayne Alexander, who's in Atlanta for us. Tamar Hallerman, a senior reporter for the AJC, Atlanta Journal-Constitution, who has extensively covered the Fulton County case. And Katie Phang, host of The Katie Phang Show and an MSNBC legal contributor. Welcome to you all, guys. Thanks for joining us on this. Tamar, I know that you've been inside that courtroom all morning. Walk us through it. What have you been seeing?
Oral arguments this morning were very brief, only 15 minutes for each side. The question is whether former White House Chief of Staff Mark Meadows will be able to change the venue for the case against him in Fulton County. He's hoping to move to federal court because the jury pool for a case like that would be broader and likely a little more conservative. He's also hoping that the judges in the federal circuit will be a little more open to some of the federal immunity arguments he plans to make. He's been trying to do this since August. He appealed an unfavorable ruling from September, and he was trying to argue that all of the conduct that's at play in this indictment here in Georgia, most of it occurred while he was chief of staff for former President Donald Trump, and hence federal courts are the appropriate venue. Prosecutors are arguing no, he's a former federal official at this point. The acts he's accused of are far outside the bounds of what a chief of staff would be doing, and that he was electioneering, and hence it should stay in Fulton County Court.
Blayne, walk us through the timeline here. What are our expectations when it comes to a decision?
Well, Yasmin, there really is no timeline for when the judges could decide. Now, when we look back on the first basically crack at this, Judge Jones took several weeks to issue his decision. So, we could see some sort of decision here from the appeals court anytime within the next few weeks. But when it comes to timeline, of course, a lot of people are watching this closely because remember, if this is knocked down again, Mark Meadows does have it within his rights to appeal that decision yet again. Now, remember, on the other side of all of this, Fani Willis has said that she wants to start the trial in August, and she's also made it clear that she wants to try all 15 remaining defendants together. She wants to have one big lump trial starting in August. So when you think about the timeline, if this is denied again, if there is another appeal, that could possibly have an impact on what that August trial date looks like, and certainly some questions around what that timeline becomes then.
A couple of things, Katie Phang, that I want to walk through. I want to walk through some of the arguments that are being made in court today that Tamar just laid out for us, and also the possibility this thing could be heading towards the Supreme Court. Walk us through first some of the arguments that are being made and how they sit with you.
Yeah, so the primary argument that we heard the judges ask, and remember, when you do these appellate court arguments, Yasmin, you want to see what the judges are asking because it kind of focuses the issues on what they're concerned the most about. And the thing we heard the most was, how can Mark Meadows possibly claim that all of the actions that are alleged in the indictment, everything that he did was tied to his duties in his federal office as chief of staff to the White House and then President Donald Trump? And the reason why that's such a critical part of the analysis is if you're trying to seek removal from state court to federal court in order to seek the protections and or the ability to do so, the conduct that is being alleged in the indictment against you, the criminal conduct that's being alleged against you in that indictment, must be related to your job at the time. The evidentiary hearing, and this is a really important point, appeals courts can only rely upon the evidence that was presented on the lower court. The only evidence that Mark Meadows advanced, Yasmin, was his own testimony. That's it. And he basically said, credibly or not, everything that I did when I was the White House chief of staff fell within the duties as the chief of staff as a federal officer. Nobody believes that. The state of Georgia didn't believe it. The trial judge didn't believe it. And you could hear the skepticism from the appellate court judges right now. That's the critical one issue. The second major legal issue is this. When we look at statutes, we want to look at what we call the construction or the interpretation of them. What does that mean? Well, you look at the plain language of the statute. Look how it's put together. Right now, there is missing the idea in this statute, the language that says that a former federal official can remove. The language in another subsection says current officials can remove. And so one of the the judges was saying, well, hey, maybe Congress needs to get involved in this if they intended for somebody like Mark Meadows to be able to invoke this removal thing. And so that's the other second major legal issue that was at play today.
So before we get to the issue of the Supreme Court and whether this is going to end up there, Tamar, bring us in on some of your reporting as to what will happen if, in fact, Mark Meadows loses this appeal and what he does next. Is there a possibility he could be taking a plea deal?
Well, at this point, we have no evidence to suggest that prosecutors have offered any sort of plea deal to Team Meadows. There's a couple different defendants at the very top of this alleged scheme, including Rudy Giuliani, former President Donald Trump, attorney John Eastman, who, as far as we understand, have not been offered potential plea deals. So I find it unlikely at this point that that will change. At this very moment, proceedings remain in Fulton County Superior Court. Mark Meadows is a part of the 15 who are currently still there, and until the federal court weighs it otherwise and says it's ours, it stays in Fulton Superior Court. But should Mark Meadows lose, it's possible he could appeal and ask for all of the judges who sit on the Federal Court of Appeals to weigh in en banc, or he could appeal this to the Supreme Court. So we're expecting this is not the last time we hear these arguments.
So, Katie, talk about the Supreme Court question here, which is essentially everything that I've been reading in analysis about this thing. It seems like Mark Meadows is dead set on getting this thing moved to a federal court. And he's going to take this all the way to the Supreme Court to make that happen. If, in fact, he loses this appeal, is that where you see this going?
Well, to Tamar's point, he could try to do the en banc, meaning all of the judges together on the 11th Circuit Court of Appeals hear the arguments again, or he could try to get it to the Supreme Court. But as we've seen in that other case that Donald Trump's been trying to do, the Supreme Court has to grant the ability for that case to be heard. It's not just automatically going to be heard. And so because of that, it'll be up to the Supreme Court to decide. You need 4 Supreme Court justices to decide if they want to take up a case or not. It could be an issue of importance, so much so that the Supreme Court says, yeah, we want to do it. But there's a couple other hurdles he still has to go in. And just a very quick footnote, Yasmin, before I stop. Yeah. Somebody who's watching this very quickly is Donald Trump. Donald Trump never did a notice of removal. He never tried to remove. I think he's carefully watching to see what happens to Mark Meadows to figure out whether or not he wants to try it himself.
Blaine, I just want you to remind folks, I know we talked a little bit about this, but I think it's important for folks to really understand why Mark Meadows is so dead set on getting this moved to a federal court and why his team, his attorneys, he himself as well, feel as if it would be more favorable to him versus staying in the Fulton County court system.
Absolutely, and I think Tamar touched on it very well. You know, the first thing is the federal immunity argument, basically saying that, hey, because I was acting as White House Chief of Staff, that's a federal role. Anything that I do underneath that umbrella falls under that. And so likely a judge in the federal court would be more open to an argument like that. But outside of that argument, I think, of course, as with everything when you're talking about many things of this nature, politics comes into play. If he were to keep his case in Fulton County, we're talking about jurors who are Fulton County citizens. Fulton County, of course, is a reliably blue county here in Georgia. It's like a Democratic stronghold. So those are the people that would be hearing his case. But if it is removed to federal court, you're talking about the entire northern district of Georgia, which includes a lot of red counties. And so the thinking certainly would go that he would be arguing before a more friendly jury pool if it was in federal court. The other thing as well, and it's something that's kind of an interesting logistical change, is that in Fulton County, it's going to be live streamed. You're going to see it on TV. It's live streamed on YouTube. None of that's the case in federal court. So if it does go to trial, if it is in federal court, certainly Mark Meadows would likely want to be avoiding those TV cameras. And that's something that he could do if it were tried in federal court rather than in Fulton County Superior Court.
Tamar, I touched briefly on the plea deal. I know you got a hold of some of those apology letters that were part of the plea deal of 3 individuals, specifically Kenneth Chesborough, Sidney Powell, Scott Hall as well. Sidney Powell's apology letter, reading this, pretty short, brief, to the point. I apologize for my actions in connection with the events in Coffee County. I wonder if there were any parameters given by in this plea deal to these individuals and with these apology letters and what they needed to include.
I can't speak to any individual instructions that the DA's office might have passed along to these defendants, but I actually interviewed DA Fani Willis earlier this week, and she said most important to her, way beyond how long it might be, is that these folks expressed remorse for what they did, that they apologized to the people that they had done wrong. The DA actually compared it to people in a relationship with one another. If somebody does something that upsets the other, you need to apologize in order to make it right. So that was at least the DA's intent of all of this, but I've seen plenty of critics over the last 18 hours or so, saying that they don't feel that remorse as part of some of these letters from especially Sidney Powell and Ken Chesbro. Scott Hall, the bail bondsman, his letter was longer. He does express remorse, in a little, many more words than some of the others. And of course, it's very different from Jenna Ellis, who read her letter while she was behind the defense table in front of Judge McAfee back in October. And she was crying and saying how she regretted what she did. She regrets becoming a part of the Trump campaign in the aftermath of the election.
Yeah, in comparison to Sidney Powell, Scott Hall's in part writes, although I certainly did not mean to violate any laws, I now realize that I did and have accepted responsibility for my actions. Just quickly, Katie, precedent here, do they usually put parameters on things like this, on writing letters when it comes to plea deals and apologies?
No, they don't. I mean, I found these letters to be wholly underwhelming and insufficient. But the most important part of the plea deal for these defendants, they're testifying truthfully when these cases go to trial, and the proffers, the recorded proffers that they gave, which we know were very detailed and very incriminating. That was more important than these, I'll call them apology letters and quotes, because I don't really think they were apologies.
Katie Phang for us. Thank you. Tamar Hallerman, Blaine Alexander. Thank you guys as well. Appreciate it.